We're back on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and also online. And then we'll call our criminal docket. People be Ralph Page. It's file 24-6875FH. Counsel, you want to state your appearances, please?
Anthony Julian on behalf of the people.
Thank you, John. Good afternoon. Brian Flynn, behalf of Ralph Page.
All right, and we're here for a docket call and also a continuing status conference on a bond violation matter. What's our status, Mr. Quinn?
Thank you, Your Honor. Mr. Juliet and I had a conversation today. We've asked for some discovery from their office with regards to some receipts for bills. We've had some estimates, but not any receipts. Mr. Juliet would have not known about my request until today, so I didn't expect you to have them today. But we can continue that. I would suggest maybe September 30th, since I'm now going to be here. A good day. We should be able to have that all sorted by then.
Okay, any objection, Mr. Juliet?
No, Your Honor.
We'll schedule it for a continued docket call and a status conference on the pending violation at the same time for September 30th at 1:40 in the afternoon. And Mr. Flynn, if you or your client want that to be a contested evidentiary hearing on that violation, please let Mr. Juliet know.
I will.
Okay, you're all set today, Mr. Page.
You also, well,
All right, let's call People v. Midget. This is file 25-7037FH. Counsel, you want to state your appearances, please?
Melissa Goodrich, Sheboygan County Prosecutor.
Good afternoon, Your Honor. Michael Hackett on behalf of Joyce Midget.
Good afternoon. And we're here for a docket call and also status conference on several pending violations. Mr. Hackett, do you know what the status on the case is or how Ms. Midget wishes to proceed?
Your Honor, we were assuming that we would proceed with the taking of a plea today.
Okay. And is there a plea agreement you can give the bailiff? All right, Ms. Midget, would you please stand and as best you can, raise your right hand for me? Just swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, you can be seated if you wish, Ms. Midget. That's fine. All right, Ms. Midget, the guilty plea hearing is an important event and includes the waiver of constitutional rights that you have. So I want you to listen carefully. If you have a question, ask me. If you need a minute to talk to Mr. Hackett, you just let me know. I have to tell you the maximum penalty for the charge that you're offering to plead to. Possession of cocaine, count 2, carries a maximum penalty of 4 years in prison and or a $25,000 fine. Do you understand that maximum penalty?
Yes, sir.
Are you on probation or parole anywhere?
Here.
For another
I'm on
case? Oh, you're on, okay. Did you have any other cases pending at the time of this matter?
No. Not currently.
Okay. All right, if you plead guilty, you won't have a trial and you'll be giving up all the rights you would have at that trial. Do you understand that?
Yes, sir.
I want to remind you of the more important of those rights. You'd have the right to be tried by a jury and at that trial to be presumed innocent unless and until the prosecutor proves your guilt beyond a reasonable doubt. The right to have the witnesses against you appear and to question them. The right to present witnesses in your own defense and have me order them to show up. The right to testify in your own defense or to remain silent and not have your silence used against you. Do you understand all those rights?
Yes, sir.
Do you have any questions for me or Mr. Hackett about any of those rights?
No, sir.
Do you wish to give up those rights and enter a plea today?
Yes, sir.
If I accept your plea, you can't come back later and tell me that somebody threatened you to make you enter it or pressured you or that you were promised things beyond the plea agreement. You waive any such claims by entering your plea. Do you understand that?
Yes, sir.
Also, when you enter a plea, you lose the right to appeal. And if you want to appeal, you have to seek permission by filing an application. The types of issues you could raise on an appeal after you plead guilty are very limited, much more limited than if you were convicted after a trial. Do you understand this?
Yes, sir.
The plea agreement provides in exchange for your plea to the possession of cocaine, the prosecution will dismiss the remaining counts, and there's a sentence agreement for 7411 probation, which means that you would the file would be non-public, and then if you successfully complete it, the charge would be dismissed. You wouldn't have a public record of the conviction. Do you understand that?
Yes, sir.
Mr. Hack, is that a full, fair, and accurate statement of the terms of the agreement?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Ms. Midget, that sentence agreement for 7411 is not binding on me. If I didn't want to follow it, I wouldn't have to. But if I didn't follow it, you would be allowed to withdraw your plea. Do you understand that?
Yes, sir.
There's an important exception to that. If you engage in misconduct between now and the sentencing, say by absconding on a bond or failing to appear, violating bond conditions, or committing more crimes, then by your misconduct, you would lose the right to withdraw the plea, even if I didn't follow that sentence agreement. Do you understand that?
Yes, sir.
Other than the plea agreement, has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you to make you do so?
No, sir.
Is it your own free choice to do that?
Yes, sir.
Knowing all this, how do you wish to plead to the charge in count 2, possession of cocaine?
Guilty.
Back on May 9th of this year, were you in Sheboygan County?
Yes, sir.
And within Sheboygan County, were you in possession of the controlled substance cocaine?
Yes, sir.
Did you know that you were in possession of a controlled substance?
Yeah.
Okay. And it turned out that that tested for cocaine?
Yes, I found out.
Okay. Do you have any reason to challenge or doubt that chemical test of the substance?
No, sir.
And do you have any lawful authority to possess that substance?
No, sir.
Mr. Hackett, you satisfied with the factual basis?
Yes, Your Honor.
Ms. Goodrich?
Yes.
Mr. Hackett, are you aware of any other promises, judgment, or inducements?
No, Your Honor.
Ms. Goodrich?
No, Your Honor.
Mr. Hackett, in your judgment, have I fully complied with the requirements of MCR 6.302?
Yes, Your Honor.
Ms. Goodrich?
Yes.
All right, Ms. Midget, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is sufficient basis in fact and law to believe you're guilty of that offense. So I'll accept your plea. We could schedule sentencing for Tuesday, October 7. Afternoon or morning work better for you, Mr. Hack?
Morning.
Okay, we could schedule this for 9:50 a.m., 10 to 10. Ms. Midget, you'll have to cooperate with the scheduling and participating with an interview with the probation department so they can write a report with recommendations. And counsel, what are we doing with the pending bond violation issues?
Your Honor, I would not object to adjourning those to sentencing and having Ms. Midget released today and see how she does between now and sentencing.
That's our request, Your Honor.
Okay, so we can continue. Continue the contempt matters to the sentencing date. And we want bond reinstated on the same terms then, Ms. Goodrich?
Yes, Your Honor, thank you.
All right, Ms. Midget, we're going to reinstate your bond with the same conditions. I want you to understand, I want to reiterate some of the things I said to you. So now, between now and the sentencing, if you stay out of trouble, there's no reason for me not to give you that 7411 at the sentencing and probably not give you any more jail. You seem to have a lot of problems on bond. If you have problems between now and the sentencing on bond, you might not get the 7411 and you're very likely to receive jail then. So I don't know, and you're not admitting anything today about the bond. I'm not asking you to. I'm just telling you, I don't know what the issues were. But you want to talk with Mr. Hackett and solve whatever those problems were so that they don't happen anymore.
Yes, sir.
Okay. So we'll reinstate bond, same conditions. It's your responsibility to contact the probation department to schedule an interview. So you want to do that right away when you're released.
Yes, sir.
And we'll see you on October 7th at 10 to 10 in the morning. Anything further, Mr. Hackett?
No, Your Honor, thank you.
Anything further, Ms. Fiddler?
No, Your Honor, thank you.
Okay, Overgrown, so I think this might be is Miss Strack present in the courtroom or she's zooming in? She must be zooming in.
All right, let's talk about that. The hearings for People v. Ralph Page and People v. Joyce Midget showed two very different stages of the criminal process, but both highlighted Judge J. Gauthier's consistent approach, measured, clear, and always emphasizing responsibility. Ralph Page's matter was fairly procedural. He was back for a docket call and a status check on a bond violation. Defense counsel mentioned discovery issues, some missing receipts and estimates, but nothing suggested fireworks. Judge Gauthier calmly set the next date for late September and reminded counsel to notify the prosecutor if they intended to contest the violation so witnesses could be arranged. It was routine, but it showed how bond violation cases can move slowly, piece by piece, until the evidence and scheduling line up. Idget's case, on the other hand, carried much more weight. She stood in court to enter a guilty plea to possession of cocaine. Judge Gauthier walked her carefully through every step, making sure she understood the maximum penalty, up to 4 years in prison, and the rights she was giving up. Jury trial, presumption of innocence, cross-examination, the right to remain silent. His tone was respectful but firm, pausing to let her ask questions if she had any. Importantly, the plea deal included a 74-11 sentencing agreement, meaning if she successfully completed probation, the conviction could be wiped from public record. That's a significant second chance, especially for someone trying to avoid the long-term consequences of a felony record. What's the judge's mix of encouragement and warning? He reinstated her bond so she could remain out pending sentencing, but he was blunt. If she slipped up again, failing to appear, violating bond conditions, or getting arrested, she could lose the benefit of the deal and face jail time. The prosecution didn't object, and her defense attorney agreed it was fair. In that moment, Judge Gauthier made it clear the choice was entirely hers. Stay clean and responsible until sentencing, or risk throwing away a rare opportunity. The atmosphere across both cases was calm and procedural. Page's case was about scheduling and paperwork. Midget's was about accountability, rights, and the promise of redemption through probation. Judge Gauthier managed both with the same steady demeanor, ensuring the process was fair while keeping each defendant aware of the stakes. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.